Okay, let's get started, everybody, and good afternoon. That is the weakest response I've heard in a couple of weeks. Good afternoon. All right, much better. I want to make sure the other people in this conference center know that we're here. My name is Scott Williams. I'm the principal attorney of the General Aviation Law Firm, and if you think you're in the right room to view top 10 legal mistakes made by aircraft owners, you are in the right room. If you meant to talk about fuel or garment upgrades, sorry, can't help you there. Thank you all for coming. I appreciate being here. I've been a member of MMOPA for a little over a year. I have a long-term desire to upgrade to a Meridian M500, and when that happens, you'll all know about it. For right now, I'm stuck flying a Cirrus SR-22T that I love very much. Okay, you probably know that every lawyer starts off with disclaimers and disclosures, and I got to do mine first. This presentation does not create an attorney-client relationship. If you actually want to engage in an attorney-client relationship, you have to sign a written attorney-client agreement, and anything that is said here today is not confidential because of everybody in the room. The presentation today might or might not apply to your individual circumstances. Everything we're going to talk about today is based upon aviation in the United States. So if you're visiting here from a foreign country, your aircraft is based outside the U.S., glad to have you here. A lot of these principles might be the same, but they might not be. And so I always recommend consult an attorney in the state or the country in which you're basing your aircraft. Okay, let's roll right into the top 10 legal mistakes made by aircraft owners. It's time to buy an airplane, and how do you start that process? We're talking about a purchase. Now, if you're buying a new airplane from a manufacturer, say from Piper, most of what I'm going to talk about doesn't apply because buying an airplane is really simple from Piper. They say, here's our contract, sign here, no revisions, no questions, that's the way it is. When you have a waiting list like Piper has, you can do that. For the rest of us, we probably know, yeah, it's still a hot market, it's a seller's market, but not as hot as it was 6 months ago, and it may cool down a bit next year. So let's talk about the purchase. First of all, whose contract you're going to use? You're buying an airplane. Do you use the seller's contract that they wrote? Do you use the broker's contract, who works for the seller? Do you go on AOPA's website and look at a template? Who's got a good idea? I have a firm belief that while attorneys are not necessary just to walk across the street or have breakfast, when you're buying an asset as large as an airplane, it is in your best interest to consult an attorney to, as a minimum, either review or write your purchase agreement. I have a philosophy, you may or may not share this, it's called the golden rule. He or she who has the gold, who's buying the airplane, makes the rules and should be the drafter of the contract. Now, a lot of brokers will say, no, we're using our contract. Okay, that's fine, but that contract may have provisions in it that are not strong enough for the buyer or may have detrimental provisions for a buyer. You don't want to go there. I'll say really quickly, there are brokers and there are brokers. Some of the broker contracts I read, reasonably well written. Some of them are just awful. AOPA's contracts, or templates on their website, have a warning and a disclosure. And it basically says this agreement or template is meant to be a foundation for your legal counsel to reference. In other words, even AOPA says don't take stuff off the web and throw it in the contract. When I see buyers or sellers writing their own contracts to avoid paying a couple of dollars in legal fees, it looks like a bad Frankenstein movie. Don't go there. Escrow. Always. When you're buying an airplane, never, ever, ever pay the seller directly. Yeah, okay, he's your brother, I understand that. Anybody else, you go through escrow because the money has to be in escrow and released to the seller when? At closing, which by definition means application for registration filed with the FAA, bill of sale filed with the FAA, statement in support if you filed an LLC, and most importantly, all liens are satisfied at closing. You don't know if this seller has a bank loan that they don't know about or a tax lien that they don't know about, and if you don't go through escrow, those liens do not get satisfied. You have an unconditional right after the inspection to walk away and not buy the airplane. If and only if your purchase agreement says you have that right. I see a lot of broker contracts that read something like, well, after the end of the inspection, the seller agrees to fix all airworthiness items in the inspection results, and if it's not unairworthy, then you're buying the airplane anyway. You know, that's That's the 737 world. For us buying airplanes that are personal to us, we want to have the right to walk away if we don't like what the mechanic says about the inspection, and that right's not there unless it's actually in the agreement. The inspection results may reveal occasionally that the aircraft is unairworthy, and maybe you decide you don't want to buy it. Sounds fair enough. What obligation do you have as a buyer to put Humpty Dumpty back together again? If you look at a lot of contracts, they're either ambiguous or they put a lot of pressure on the buyer to restore the aircraft to its pre-inspection condition. And that's fine, but what if putting it back to its pre-inspection condition isn't possible because the mechanic says, I can't put it back together again and sign off on it, it's not airworthy. Well, I put a provision in my agreements for the buyer's protection that if you can't do that within the scope of an inspection, then the seller is going to have to handle it. I don't want a buyer taking on liability to fix the seller's problems. So, questions about purchase? Okay. Oh, hang on. I skipped a half a slide. Make sure that in your purchase agreement there are certain seller representations and warranties. What do I mean by this? First and foremost, clear and marketable title. If you don't have good title to your airplane, you don't want to buy it. If there is a lien or something filed 20 years ago, look, I know the likelihood that that's ever going to be an issue is thin, but it's there. I just did a deal where there was a conditional sales contract filed some 30 years ago on an airplane, and it was never perfected, and it was never paid off, and it created all kinds of problems. You also want to make sure the seller is warranting that all taxes are paid on the aircraft. That's sales tax, personal property tax, use tax, and the seller should indemnify the buyer for any tax obligations that occur up to closing. The taxes that are incurred as a result of closing, meaning buying the aircraft, should be the buyer's responsibility, and their indemnification works in the opposite direction. The buyer should indemnify the seller to cover taxes related to the transaction. If the seller is an entity, it's usually a single-purpose LLC, it has no assets other than owning an airplane, you better get a personal guarantee by the seller, because what often happens after that LLC sells its only asset? It's gone. It's dissolved. It doesn't exist. And realistically, who's going to have more of a claim after closing that something was wrong? A buyer or a seller? A buyer. Seller's got the money. Highly unlikely they're going to have a claim against a buyer. Far more likely you're going to have a claim and you want a personal guarantee. If someone doesn't want to give a personal guarantee, ask them why. Closing should be in a tax-friendly state. In other words, if your particular home state doesn't have a sales or a use tax, you don't want to close in some other state that does and incur an unnecessary tax. Even if the state you're in has a flyaway exemption, some of these states are just miserable to go through the process to get the exemption. California being one. Even though we have technically a flyaway exemption, it's paperwork after paperwork. So if you can close in Oregon or some other tax-free state, or maybe even South Carolina where the maximum tax is $500, close there, then worry about sales and use tax when you get back to your home airport. There should be a provision in every agreement for attorney fees to the prevailing party. And I say this not to encourage litigation, but I say it because if this provision isn't in the agreement and you have a legitimate dispute, it makes it more expensive to make your claim than the claim itself. So, look, I don't encourage litigation, but you don't want to have a situation where nobody sues anybody because you can't afford to enforce your rights. I do believe strongly when it comes to things like venue and forum that neither the buyer or the seller should have what's called home field advantage. You have to schlep someplace else to file a lawsuit. The default rule, by the way, in America, you have to file the lawsuit where the defendant is located. So for that reason, I recommend, and I put in all my agreements, what's called alternative dispute resolution. You got a dispute that exceeds the value of a small claims court. You first go to a non-binding mediation where they typically settle 85% of all disputes. In the unlikely event you still can't settle it, settle by binding arbitration. The arbitration is conducted by video conference. Nobody has to go anywhere, and you get a quick and relatively private resolution. Courts are ugly, they're expensive, and they're very public, and I don't like doing my dirty laundry in public. Okay, questions on purchase agreement? There's one over here.
It's just about the airworthiness thing. I mean, in most situations, unless it's going for annual, why would start with the mechanic
I've seen mechanics take things apart and say, this is so corroded I can't put it back together again. I mean, it doesn't happen very often, but it might. I don't want you taking on that liability. Okay, moving on to mistake number 2. How are we going to hold title of this airplane we're looking to buy? What's the best way to hold title? How about individually? Anything wrong with this? Not necessarily if it's for personal use only, and, this is the big kicker, nobody else is going to fly the airplane but you or the co-owners, then fine. The problem is if it's not held in an LLC or a corporation, you can become personally liable as the aircraft owner for everybody else's mistakes as pilot in command. So most of us don't think about this, but we're probably going to have somebody else ferry our airplane someday to get it to maintenance, to whatever. And when that happens, I really like to see the protection of an LLC or a corporation. When I say a corporation, LLCs are the preferred legal entity if that's a single purpose, but if you have a business corporation, sometimes I see people put aircraft actually in their corporation. Yeah.
What about a situation where you're already paying your aircraft very maintenance shops, so don't worry about it, we got insurance that covers that.
Right. So the problem with the maintenance shop's insurance is the same problem as your insurance. Most of us don't realize that aviation insurance ain't like car insurance. Anybody gets behind the wheel with your permission, guaranteed coverage, no questions asked. In an aircraft insurance policy, if for any reason that pilot doesn't meet all of the open representations and warranties of that pilot, like their BFR is 1 day expired, the carrier says no coverage. And in many cases, the shop says they have coverage, but if you look at the fine print, it's a commercial general liability policy that actually excludes aircraft in flight. What they really have is the danger of taxiing an aircraft, bumping into hangars. That's the coverage most shops have. Very few shops have in-flight coverage on their policy.
All of that is, if they offer that service to you, what specifically are you asking besides do you have insurance to cover it?
I don't ask, do you have insurance? I say, send me a copy of your insurance policy or the certificate, because most of them can't produce an in-flight policy. Again, shops don't normally fly airplanes. They may taxi an airplane out to the ramp to do a run-up. That's fine, and they have coverage for that, but they don't have in-flight coverage. All right, so if you're not going to title it an LLC or corporation because you say, I'm going to title the airplane, I'm going to fly the airplane exclusively, you should make sure that you have it as a very minimum in a revocable living trust for probate avoidance. Where should your LLC be formed? Who likes Delaware? Who likes Nevada? Who likes the Grand Caymans? All right, trick question for the audience that ain't so much of a trick. Where should your LLC be domiciled? The state where your aircraft is primarily based in. I know there's lots of people out there that say, oh, you got to be in Delaware. Delaware is a great state to be in because you avoid lawsuits. And they just don't understand that when an airplane crashes, the state of domicile of the LLC means nothing. Aircraft accidents are adjudicated where the accident takes place. You've got a Delaware LLC, the owner lives in Kansas, the crash is in Montana. Where is the litigation going to take place? In Montana, and it doesn't matter where your LLC is formed. The reason why Delaware and Wyoming and Nevada and all these other out-of-state LLCs are really not a good choice is because even if you did register your LLC in Delaware, fine, you then have to register your Delaware LLC as a foreign, aka out-of-state LLC, because your aircraft is based in Kansas. So why pay duplicative fees for no real benefit? Anybody that tells you you should be incorporating or LLCing in Delaware, ask them a very simple question. What does this get me in the long run? Do I really avoid having to register my plane in Kansas or my LLC in Kansas? The answer is not really. You should be in a revocable trust if you're not going to put it into an entity, just to avoid probate. Most states have a probate avoidance for vehicles and vessels, but not for aircraft. Good question. Sales tax is based not on what legal entity owns the airplane, but is based on the transaction itself. If you sell an aircraft in a state where there is sales tax, then there is sales tax. I don't care if it's registered in Delaware, California, the Grand Caymans, or any place else. Use tax is based on what? where you're using the airplane, aka where you're basing the airplane. So you can buy an airplane in a tax-free state like Oregon. The minute you bring it into California, you're going to pay use tax unless you can meet a tax exemption, and the state of the LLC is no protection whatsoever.
You said rev trust.
Uh-huh.
If you have a plane in LLC, can you move it into a rev trust?
Actually, it's even easier than that. If your plane's already in an LLC, you just transfer the membership interest of your LLC into your trust, so you have the probate avoidance, but you still have the liability protection. Okay. Mistake number 3, I call it insurance ignorance. How many people in this room have actually read your insurance policy? The one that's 78 pages plus addendums. Okay, yeah, not the certificate of insurance that's a page or two. Okay, I'm talking about the actual policy. Most of us haven't read it for whatever reason. All right, so look, here's the bottom line. I like insurance brokers most of the time. Most of us don't realize that an insurance broker owes no fiduciary duties to you, the insured. In other words, they don't have a legal duty to shop for the best policy at the best price with the best coverage. You think they do, but they don't. A real estate broker in almost every state has fiduciary duties because they're statutory. Those statutory protections are not in existence in the world of insurance. Now, a broker does have a duty of competency to not be incompetent and get you a policy that has no coverage, but they don't have that obligation to shop. What's the message here? Get a good broker relationship. Treat them well, ask them to treat you well, and if you feel your broker isn't out there working for you, don't be afraid to go to somebody else. You should know that in the world of aviation and business insurance, you can't call multiple carriers to get multiple quotes from different brokers. You have to have what's called a broker of record letter, which means only one broker is going to be able to get you quotes from multiple carriers for your particular aircraft. They'll only quote one broker if they have a broker of record letter. Read the actual policy. Yeah, I know it's dry reading, but if you don't get it, don't worry about it. I'll help you out. You should know what the definition of a covered pilot is. A lot of people are confused by this. So there's 2 kinds of coverages in an aircraft insurance policy with regard to pilots. You have a named pilot, which is the best kind of pilot, and then you have what's called the open pilot warranty. A pilot has to have 500 hours, 100 hours in type, instrument rating, currency, whatever. The reason the named pilot is so important is carriers don't subrogate against named pilots when things go wrong. If you are merely a pilot flying on an open pilot warranty and you're not the actual insured, when things go wrong, the carrier does pay off the claim, like paying off the bank for your airplane. And then they come after the open pilots that were flying the plane. Happens all the time in flight schools, happens less often in private policies. It's just too risky. Don't go there. Anybody flying your plane who you care about should be a named pilot. You got a CFI, you fly with him or her and you like them, and you don't want them to get sued because of their negligence, get them listed as a named pilot if at all possible. That's not to be confused with having them be an additional insured on your policy, and here's the difference. When people are additional insureds, it means they can invoke the rights of your policy at any time. So if you own your airplane in an LLC, who should be an additional insured? The member that owns the LLC. Should your CFI be an additional insured? No. They should be a named pilot, but not an additional insured. You don't want somebody filing a lawsuit against the CFI, having them exhaust your policy limits, then finally you get the lawsuit and your policy limits are gone.
Is that the same as waiver of subrogation?
Yeah, very close. Named pilots, well, technically a waiver of subrogation would be nice to have it enumerated. I just don't see carriers subrogating against named pilots. So it's implied that if you're named, there's a waiver of subrogation. But open pilot warranty, you're fair game.
The expense of an open pilot, or not an open pilot, additional insured versus somebody in your LLC. What is that?
Okay, so when you call your carrier and say, or you call your broker and say, I want to make sure when my policy is issued, that it's issued to the LLC because the aircraft owner has to be the policy insured. Make sure your broker gets you, the member, or members, listed as additional insured. Doesn't cost a thing. What costs money, and we see this happening right now everywhere, is your FBO, where you keep your airplane, is saying what to you? We want to be an additional insured. And that's where the broker is saying, sure, I'll put the request in, and the carrier comes back with, we're happy to do that for $1,500 a year. Look, I think it's highway robbery. That's outside the scope of this presentation. If I could shoot some FBOs right now, I'd be happy to do so. We'll cover that later. You got to read the reps and warranties in your insurance policy specifically for what is excluded. Now, you have to understand that aviation insurance isn't like car insurance. If you violate any of the representations and warranties, that pilot doesn't have coverage. Most policies have requirements. They have to have a current medical or basic med for that type of flight if it's allowed. You have to have a current BFR, and if you're flying a jet, you got to have a 6158, and sometimes other training requirements. If there's a training requirement in your policy and you let the requirement lapse, let's say you have to go through some kind of a annual flight review, even if it's not required by the FARs, and you don't take that annual flight review with an instructor, and then you have an accident on the 366th day. Does your carrier need to prove that the lack of training for one day caused the accident? No, they can just deny the coverage. In most states, called the majority rule, any breach of the reps and warranties by the aircraft owner, the insured, causes a lack of coverage of that pilot. So you got to put on your calendar all these things that make you covered as a pilot and make sure you never let them lapse. I did a case 3 years ago. Cessna 182 has a gust lock installed in the airplane, puts it on the wrong side so it's not blocking the key, forgets to take it out, goes sailing down the runway, starts to pull back and says, ain't nothing happening here. Oh yeah, the gust lock is installed. Pulls back to power, not in time, aircraft goes to the fence. Fortunately, nobody was hurt badly, but the aircraft was totaled. His BFR expired 2 days earlier. The carrier said, no coverage, end the conversation. Happens. Insurance carriers put policy clauses that are not necessarily to our favor. We call them betterment clauses. A betterment clause basically says, if we, the carrier, fix your airplane's damage and it causes us to better your aircraft, meaning substantially improve its value, we want to prorate that somehow and not pay you all the money you're entitled to. You've got to be very careful when carriers try to play these games. Certainly, if they're putting on a brand new part that was about to fall off anyway, maybe. But a common situation you see here is in engines. Who in this room flies a piston engine? Okay? What's your TBO? How far? 2,000 hours. That means at 2,000 hours your engine's toast, right? No. I'm in the Mike Bush School of Reliability-Centered Maintenance. I flew my first IO360 engine to 3,200 hours, and it ran just fine. So bottom line is here, just because the carrier says, well, your engine had 1,800 hours and TBO is 2,000, we're only going to pay 10% of the cost of the rebuild. No, don't let them get away with this. That does not substantially increase the value, and TBO is, as Mike Bush would say, just a number. Okay, we're talking, in this room, we're talking Part 91. Yes, sir. It's not the policy that you have to modify. It's what happens when a claim occurs and the carrier tries to expand on or twist what the betterment clause actually means. This is where you got to push back, and frankly, you need an attorney to push back when you have a claim. I don't mean to disparage all insurance carriers. A lot of them are very good. You have a claim, they pay it, there's no issues, and everything's fine. But I get the call once a week from, hey, I had a claim and they're willing to pay, but my damage is 50 and they want to pay 30, or my damage is 400 and they want to pay 100, or something like that. And almost always I hear the word in the conversation after about 35 seconds, betterment. So it's not that the carrier is going to change their policy for you, it's when the claim happens, you've got to get a warrior to push back for you. No, they're not negotiable. It's like Piper Aircraft's sales contract. All right. Mistake number 4 most aircraft owners make is they have either bad contracts or worse, no contracts. If you have an aircraft owned by 2 or more people who are not already husband and wife, you need what kind of an agreement? A co-ownership agreement. Now, if it's part of an LLC, we'll call it a membership agreement, or if it's owned by individuals or multiple LLCs, Look, you got to know what your rights and responsibilities are to each other. And I know you're getting along well, and I know this co-owner's been your friend for 30 years, and I know you all hang out in the local bar every night and drink together, but contracts keep honest people honest, and they help avoid misunderstandings. What happens when one of you wants to sell and the other one doesn't? What happens when one of you dies and you don't want your ex-partner's widow as your new aircraft partner? If this stuff isn't in an agreement, a whole bunch of bad things happen and there are unintended consequences. If you are leasing back your airplane to a charter operation or to a flight school, there needs to be a contract. Who typically writes those contracts? The charter company or the flight school? How one-sided can they be? Very. You need an attorney to review what's best for you, and sometimes if the flight school or charter company is so draconian in their language and they won't budge, it's best to walk away. It's just not worth it. If your business is using the aircraft and it's not owned by that business, meaning you have the aircraft owned personally by you or by a separate LLC, there needs to be a lease agreement for tax purposes that connect this nexus. And taxes and aircraft is kind of outside the scope of our presentation, but I will say that without a written agreement, you're kind of wide open for tax purposes, claiming how much of this is owned by who and what the pass-throughs are. All right, mistake number 5, one of my favorites, inadvertent flight into Part 135. How many people in this room fly their aircraft every day as Part 135 pilots? Okay? Nobody. All right. How many think you're Part 91 but aren't really sure if you are? Nobody's hands going up. All right. Bottom line, we all fly Part 91 here. Part 91 is the least restrictive form of flight known to mankind in the world of the FAA. What triggers Part 135? Well, anytime you're renting seats on the aircraft or renting space on the aircraft to fly cargo to get it someplace, unless you're in a very narrowly defined exception, you're in the world of 135. The FAA frowns on what they call Part 134 and a half, which is you don't have a 135 certificate, but you're kind of operating under what needs to be a carrier. You don't want to be ever alleged to be an illegal air taxi operation, because that's when it gets ugly. Not only is your certificate at risk, but you've got substantial fines and penalties for that kind of an operation. So what it basically, yeah.
You can volunteer to take, through some organization to take family members to a hospital where their child is or something like that.
Flying friends to get someplace, like to a hospital, the FAA doesn't mess with that. I fly for Angel Flight West. That's not Part 135. That's Part 91 all the way. But you're not taking money from Angel Flight West, are you? Right, okay. So the definition of a wet lease basically means that the pilot and the aircraft owner are one. In other words, you're providing both the aircraft and pilot services from the same person or the same entity. That's the trip, the event that trips up most pilots, because they don't understand that. So, common situation. You own an aircraft in a single-purpose LLC. All that LLC does is it owns an airplane for liability protection. Does that create 135? Not at all. Then you, personally, as the member, go fly the aircraft. Does that create 135? It depends in what capacity you're flying the airplane. If you're flying the aircraft on behalf of the LLC as its member, that's a wet lease. That puts you in 135. Who needs to be flying the airplane? John Doe or Jane Doe, the individual person who is not acting on behalf of the LLC, creates the dry lease that is perfectly fine with the FAA. What's the message here? Anybody that owns an aircraft in an LLC needs to have as a bare minimum a dry lease agreement. And the dry lease agreement here has nothing to do with taxes. The dollar amount per hour flown can be zero. What the FAA cares about is what's called operational control. The definition of operational control is who has the authority to commence and terminate that flight and tell the aircraft where to go. That's the pilot, you the individual, not the LLC that owns the airplane. So as long as you're doing that, you're fine. Is leasing out an airplane from an LLC considered a wet lease? No. If you're only providing the aircraft for whatever dollar amount you choose to rent it for, that's fine. But somebody else needs to provide the pilot services, and that really can't be you as the member, because now the FAA says you're all one and the same. You are permitted, as most of us know, to charge a pro rata share of the expenses. So 3 people are going to come to Tucson for the great conference we're all having here, and we're all going to share expenses, split the fuel, split the tie-down fees, the FBO fees, 1/3 each. Is that permissible? Absolutely. If you charge $1 more than the pro rata share, that's where you fall out of 61-113, and now you start operating like a charter. Be aware of what you can and can't prorate. It's variable expenses only, not fixed expenses. Not the cost of your hangar, any part of your insurance, any part of your aircraft payment. It's basically fuel, oil, parking fees, ramp fees. Those are fine. Any other fees are considered fixed, and you can't prorate them. But what's that? Engine reserve, no. No. No and no. So, if it's not a variable expense, it's an actual cash outlay, no.
So, you lease the plane from somebody for $500 an hour, that's what it is.
Right. If I'm renting an airplane from a flight school, or a friend of mine, and the cost is $1,000 an hour, and I got 3 friends all want to go flying, yep, I can charge them 1/3 of $1,000 because that's a direct cash outlay operating cost. Now, to invoke 61.113, there's also one other requirement. It's called the common purpose test. You all have to be going either the same place for the same reasons or something very close to that. What you can't say is, I'm flying to Tucson from Kansas to go to Mmopa. Does anybody else want to fly in that general direction, and I'll drop you off along the way? Even if you do comply with all of the other pro rata limitations, it fails the common purpose test because now you're kind of renting seats on the airplane. Just don't do that. All right, number 6 mistake, unauthorized maintenance. Who in this room likes to work on their own airplane? Go ahead, put your hands up. It's a symbol of pride. You know, I always have the joke that there's nothing more dangerous in the world than a lawyer with a wrench in his hands. So says my A&P when I did my first owner-assisted annual. All right, so we've all heard the expression, what is legal is not necessarily safe, and here I'm going to talk about what's safe might not be legal. I don't care how much of a wrench you were a mechanic in the armed forces working on airplanes, and now you're working on yours. There are very strict limitations as to what you can do as an owner legally. And I reference the Bible, which is Appendix A, Subpart C to Part 43, that lists out a whole bunch of things that you can do as owner-authorized maintenance. And I say to people, as bluntly as I can, if it ain't there, it requires an A&P to sign off on the work. Now, there's a little gray area. I know Mike Bush, who I admire and respect, and we agree on almost everything. He says, look, that's not really an all-exhaustive list. If it's something very close to what's listed there, and it really kind of meets the FAA's requirement of intent, you're probably okay. Maybe he's right, maybe he's not, but I don't want to get the phone call from you saying the FAA is accusing me of unauthorized maintenance because it wasn't in the Bible. So I tell people, please do what's in the list and nothing more. What about if the owner does the work and assists the A&P? Is that okay? Sure. What if the owner does the work and the A&P signs off afterward? The answer here is it depends. Does the A&P who's signing off have the opportunity to inspect every aspect of your work to make sure it was done correctly? If anything has since been covered up or otherwise it's inaccessible for the A&P to determine whether you did it right or not, then by definition he can't sign off on it or she can't sign off on it. So it's okay for you to do the work and the A&P looks at it as you're doing it, inspects it along the way, but the classic example of you'd go do your annual inspection, tell me it was done later and I'll sign off on it, is the A&P renting out his or her license for a fee, and that's when the FAA says you're no longer an A&P. Mistake number 7 is the failure of all of us to maintain airworthiness of our airplane. So trick question, who's responsible to make sure your aircraft is airworthy? The owner or the PIC? I heard somebody say both, and the answer is that's usually the correct answer most of the time. When you're pilot in command, you absolutely have an obligation to make sure that the aircraft is airworthy, within limitations. Are you required as a PIC, every time you fly a rental airplane, to go through all of the AD compliance of that aircraft ever since it was manufactured? No. There is a theme or a legal theory called justifiable reliance. You are allowed to rely upon the owner who, by virtue of the fact that they're renting you the airplane, did all the airworthiness directives. So you can rely upon the owner for most stuff as PIC. Now I'll ask this question. Who can the owner rely upon to make sure it was done right? I hear the word sometimes the mechanic, and the answer is not really. The owner of the aircraft has the ultimate responsibility to make sure your aircraft is by definition airworthy, and that means, in a nutshell, all airworthiness directives complied with, registration is current. You all know that an expired registration invalidates the airworthiness certificate, therefore the plane's unairworthy. Don't fly an expired registration because now your insurance company says we're not covering your crash. No joke.
Right now, registrations are processing in March.
Aha! Right. I can. So I'm proud to announce that I was one of the attorneys who spearheaded AOPA's drive to get the FAA to realize they could not process these in 90 days like they're supposed to. And so now they've instituted automatic extensions. So you get your temporary application that's good for 90 days, and about a month later or so, you're supposed to get an extension. If you didn't get one, ask for one. They're liberally giving them. They know they can't do registrations in 90 days. But if you don't get an extension, technically you're unairworthy. With the responsibility here, all I can say is, yes, you can rely upon your mechanic that the screw got tightened with the proper torque. That's okay. But you can't say to your mechanic, oh, you were supposed to track my annual inspection date, and you didn't let me know. Not going to work. How about airworthiness directives versus mandatory service bulletins? Does an airworthiness directive have to be complied with for the aircraft to be airworthy? What about a mandatory service bulletin? For Part 91, the general rule is no. There's a couple of rare exceptions not worth going into, but you're correct. Now, under Part 135, almost always mandatory means mandatory, and you must comply. This is often an interesting question. How many people here fly an aircraft that has a minimum equipment list? How many don't know what a minimum equipment list is? All right. Most of us fly airplanes, if you're in the piston world, where you don't have a minimum equipment list. You have what's called a kinds of operation list in your pilot's operating handbook, and the kinds of equipment list will specify what equipment needs to be working in order for the aircraft to fly under that type of flight. For example, if your strobe lights are out, you can still, sometimes fly VFR day, but in some aircraft like my Cirrus, if your strobes ain't working, you're grounded. You can't fly at all. So what does that mean? It means you have to consult your kinds of operations list. And if your aircraft does have a minimum equipment list, like who's an M600 owner here? Okay, you have one because Piper created a master minimum equipment list, and anything that's not working needs to say it's okay to fly with that equipment not working in that list. My favorite story is the good to go, says the mechanic. Guy is flying a Hawker jet from Southern California up to King Salmon, Alaska to do some fishing. It's a Part 135 operation. Pilot's very experienced, airline transport pilot. He's also an A&P. They get a high temp fuel warning light on one of the engines, and they make a precautionary landing at Oakland, where Kaiser Air takes the plane apart, or takes the engine apart, and basically says, yeah, you've got a card that needs to get replaced. Can't fix it today, don't have the part. I can order the part now, we'll drop ship it tomorrow morning. It'll be here at 8:30, and I'll probably have your airplane done by noon. Not too bad. So they overnight in Oakland, and then of course this pilot, who's an A&P, likes to be very involved in the work. He's watching him do the work. He's kind of, seeing what's going on. He comes out with him for the flight test, the ramp test at the end of the ramp, and they run everything up, and the temperature warning light goes away, and the mechanic says, good to go. So the mechanic, unknown to the pilot, goes back in the shop and starts filling out all the paperwork, while one of the other mechanics was supposed to safety wire the card in a certain fashion because that's what's supposed to get done. What nobody knew was the pilot was loading the passengers onto the airplane, and they took off. Not only was the maintenance log not signed, but there was also a safety card, a card that wasn't safety wired properly. So they landed in Alaska, and who got the phone call? The pilot. And who's on the phone? the FAA because the shop called the FAA when they were 5 minutes out saying, hey, this plane took off and we hadn't fixed it yet. Bottom line is this: even if that card had been properly safety wired, was that plane airworthy without a maintenance sign-off? Every time a mechanic touches your airplane and does something more than remove the cowl, which we can do as owners, it grounds the airplane until you have an actual sign-off by an A&P with a certificate number saying return to service. The signature of the A&P is the return to service. Good to go is not good enough. How many of us have landed in remote airports, got a quick fix, and said to the mechanic, mail me the logbook stickers? Come on, put your hands up. We've all done it. What needs to happen? Well, in a perfect world, I'll wait for the logbook stickers. I will give you a practical approach. If you can have the mechanic send you a text message with their certificate number saying return to service, I've talked to the FAA, they're good with that. In a Part 91 world, they're good with that. I'm not saying they're going to advocate it, but it'll get you out of trouble. Not going to work on 135, but it'll work for our flying. Just make sure you have a certificate, a logbook entry always. All right, number 8.
Quick question on Mel. So for Mel to be legal, you need to have specific.
Two kinds of minimum equipment lists. You have a master minimum equipment list that is from the manufacturer, like Piper has done with the M600. For all other aircraft owners, it's specific to your aircraft. You have to submit the proposed MEL to the FSDO, get a letter of authorization saying approved, and then you can use it for your aircraft only. Even if your hangar neighbor has the exact same airframe, you can't use their minimum equipment list. All right, coming back here to shop contracts. Are contracts with your shop oral, written, or a combination of both? Usually a combination of both. There's a written contract called terms and conditions on their invoice, and there's a lot of email exchanges and a lot of verbal exchanges. Someplace in the shop's invoice that you've received before, there's on the back 38 pages or 38 very small fine print terms and conditions. Are those terms and conditions binding in 8-type font? Yes, they are. So you better look at them. Make sure you know what you're doing. You're doing an annual inspection. This is the number one thing owners screw up on. They drop off the plane for annual. The minute the shop starts your annual, what happens? Aircraft is grounded. Okay, it cannot be flown again until it's signed off. And if you're past the annual date, signed off as an annual. What is the shop authorized to do when they agree to do your annual inspection for a flat rate? To inspect, to find things, and to send you a discrepancy list. And they're supposed to send you 2 lists, airworthy items and non-airworthy. Does the shop have the authority to fix airworthy items? This is interesting. It kind of depends upon your relationship with the shop. If you have always told your shop, look, it's going in for annual, fix what's airworthy, let me know about the rest, and they follow that same standard routine, that's probably, you're stuck with those bills. So I tell every shop in an email so there's no misunderstanding. You're authorized to do the annual inspection, to get me a report, we've agreed upon a price of X, don't do any further work until I have reviewed the discrepancy list. That's how you, the aircraft owner, take control of your finances. Mostly good shops out there, but there's a few that are sloppy, some unscrupulous. You don't ever want to give a shop a blank check to do anything. You need to be able to say no to those that are non-airworthy items. If you think your shop is being overzealous and writing up airworthy items that are really not, get a second opinion. Worst case scenario, get a ferry permit, take it someplace else. But don't get stuck paying a huge bill to a shop that says your airplane needs $100,000 in repairs. Yeah.
So if you take it into a shop and they give you that list of ATs, and you're not sure about others, you need a ferry permit to move it?
Yeah, because without a ferry permit, unless he's not signed off on it, you're going to need a ferry permit. All right. Mechanics liens. When is a mechanics lien created in an airplane? I'll give you another trick question. What section of the FARs governs mechanics liens? What's that? It doesn't. Mechanics liens are a function of state law. So wherever your aircraft is being worked on, not where it's being based, not that you have an LLC in Delaware, but if it's being worked on in Texas, Texas law applies to aircraft mechanics liens. And every state's different as to when that lien attaches and what the shop needs to do to actually perfect the lien so as to actually create a encumbrance on your aircraft. Just be aware when a shop threatens a lien because you're not getting along well, that's when you need a lawyer. Once the lien goes on, it's difficult to get it off. All right, now we're going the opposite direction of buying an aircraft. We're finally selling our aircraft. We always call aircraft our baby because we feel like parents. All right, whose contract? Again, same question in reverse. All right, well, if I'm selling an airplane, I'd like to write the contract, but I'll respect the fact that a buyer wants to write it if it is a reasonably well-written contract from a credible source like an aviation attorney. I love when family law attorneys write aircraft contracts. For the same reason I don't do prenups, they shouldn't be doing aircraft contracts. Please don't ever say in your purchase agreement that your aircraft is airworthy. Never, ever. Because frankly, you don't know if there's something in that aircraft that isn't right that would cause that aircraft to be legally unairworthy. It is okay to say, I've complied with all airworthiness directives. That's a reasonable representation for a seller to make. Don't even go so far as to say, to the best of my knowledge, the aircraft is airworthy. Because if there's ever a dispute, now your knowledge of what you had or didn't have becomes a triable issue of fact. Never represent your plane as airworthy. If I'm ever asked by a buyer, is your airplane airworthy? Is your plane safe? What's the response? Go ask your pre-buy mechanic. Safe answer. You need to say flat out, this aircraft is being sold as is, where is, with no warranties expressed or implied, not for any particular purpose, and you have the skills that are necessary to operate the aircraft because I'm not giving you any training. Now, there's some exceptions in the EAB world where sometimes you have to give somebody training because nobody else is around. But as a general rule, you don't want to have somebody crash an airplane and complain that the seller didn't properly train the buyer. Sometimes you're going to have contingencies in contracts, like a financing contingency. Okay, if you want to allow that, that's fine, but you better make sure there's limitations on there, like your contingency is automatically removed in 10 days unless I give you an extension. Don't let somebody tie up your airplane for 30 days while they're still working on getting financing. Finally, what happens if the buyer backs out? Well, if they back out up to including the pre-buy results, that's usually okay. They get their deposit back. But once they accept the airplane, the general rule is that they have now breached the agreements. And once they breach the agreement, do you want to start arguing over what your actual damages are? Too cumbersome, too costly. Just set up liquidated damages. Whatever the deposit is, usually 5%, becomes liquidated damages. They are retained by the seller, and the buyer is then released, and you go sell the airplane to somebody else. You probably sell it for the same price anyway, and you keep the 5% in your pocket. So that covers 1 through 9. Mistake number 10 is not asking enough questions. Who has some questions? Back there. Yeah.
Question about the minimum equipment list. Topic on the forums kind of going around. The notion is whether minimum equipment list is kind of a sliding or free kind of card. So, say you're flying home, flying to some destination, some use of equipment fails, your generator fails. Now you're stuck at home, and how do you get to your maintenance shop?
Okay, so that's not really an MEL problem. That's really a practical problem. You got a part that's not working. So in your hypothetical, do you have or not have an MEL? Okay. Well, it's a big difference. If you have an MEL, then you have to have that part has to be that piece of equipment has to be on the list as authorized to be inoperative. If you have a kinds of equipment list, like most of us have, unless you're the M600 crowd, then you look at that list and see what types of flight are authorized or not authorized for that particular flight. Either way you slice it, you could be grounded on AOG without any reasonable way of fixing your airplane. It's just the way it is. I mean, my airplane, if the strobes aren't functioning, I can't even fly day VFR. So what do? If you're flying the old style strobes, you carry backups.
On your point about mechanics, you
Mm-hmm.
mentioned that taking showering might not be an issue. That's something we can do. We can also do oil changes. Does that apply with things like an oil change?
No, doing an oil change is fine. Now, technically, you're supposed to log the oil change the same way a mechanic would. I don't see the FAA coming after you for not logging your oil change. What I see is the shop did an oil change, but they haven't done the logbook sticker yet, and you go flying, because even though you think it's done, maybe the shop didn't do the logbook entry because there was something else they still had to do. The whole purpose of that regulation is to take the guesswork out of the process. By the way, the story of that mechanic got a 150-day suspension from the NTSB administrative law judge. We appealed it to the full NTSB. We got it down to 60 days. And the pilot. The mechanic did nothing wrong. They were back, writing up the work order when the guy left unexpectedly. The pilot, who is an A&P and an airline transport pilot, was supposed to know better, although the FAA thought that the 150 days was too severe of a penalty. The FAA screamed about that one, by the way. He says, how dare you, NTSB, overrule the trial? Come on, guys. All right, time for a couple more questions.
Aircraft is owned by the LLC, but it's just the ownership. You pay all the bills personally. You get the hangar rent, all the everything. But you need a dry lease to the member.
You do. So when you say you pay all the bills from the LLC, you pay all the bills except for pilot services. If you ever need a fare of the aircraft, the LLC never writes the check. The individual person who needs to get the aircraft someplace writes the check. The dry lease is not about money. The dry lease in the terms of the FAA is who has operational control to start and end that flight. That person is the individual, you, who happens to be the member of the LLC, not the LLC itself. Technically, no. For small aircraft that are not turbojet and are under 12.5, they don't have to be carried in the aircraft. Having said that, we all have iPads. You can put it in your iPad in about 2.5 minutes. Just do it, in case you get RAM checks. A couple more questions.
If you have the aircraft in your own name and you're using it for business purposes, what does that lease agreement need to look like? What do you have?
Then the lease would be from you individually to your company, and now we're getting into tax issues where there'd be a dollar amount there. Basically, you personally owning an aircraft in your own individual name, the FAA isn't concerned about a flight company department. They are when entities own airplanes, and the only purpose of the entity is to own an aircraft. Now, if you're Citibank and you've got a fleet of Gulfstreams, do they care about that being a flight company department? No, because it's an operational business. Their main purpose is banking that aircraft. Over here.
I find the whole Part 91 and 135 for an owner-owned and operated aircraft with commercial license very confusing. Is there some place that is the final word, or is Tommy like an ask?
Sure, you could ask me. And you are. Look, bottom line is, are you renting seats on the aircraft? Are you renting space on the aircraft? That's kind of the test. If I'm asked by a friend of mine to ferry his aircraft or her aircraft to a maintenance shop, and I get paid a fee to transport the aircraft, but I'm not carrying people, I'm not carrying cargo, I'm just moving the aircraft, and I have a commercial license, getting paid is a Part 91 commercial operation. Sightseeing within 25 miles is usually a commercial but still a Part 91 operation. What crosses the line into Part 134 and a half, which the FAA rounds up to 135, is when you start renting seats on the airplane or sharing expenses and you violate the common purpose test.
Well, as far as Congress has voted themselves, there's also a little thing where you can also fly a person that is running for office.
I'm not going there.
Can you believe that?
Yeah.
You raised the question. I made a comment. Secretary of DOA to the aircraft.
Not supposed to. Must. Must. Yes, supposed to as in shall. Mandatory, yes. Right. Okay. Okay. I'm going to give you two answers. I'm going to give you the legal answer. I'm going to give you the FSDO answer. Because the FSDO isn't always right. The copy of the POH that is electronic, the ones you can download, is not a true POH. What's missing from that POH that you download? Weight and balance and the signature page from the office that signed off the aircraft originally. So the short answer is, if you download 98% and then you also scan and upload the weight and balance that's current and that signature page, and you put it all together in one PDF and you throw it in your iPad, my argument is that is legally compliant. If you ever lost your paper version, I would still fly the airplane personally under Part 91. But a downloaded version alone without those two key components is not compliant. Yeah.
Here's my specific case. I have literally PDF every damn page of that DOH.
Fine.
It's not off the internet.
All right, fine. If it's me, I'm going to fly, and if the FSDO comes after me, I'll fight him on it, because to me, I think the risk is worth the reward. I would not. Now, common question we often get asked is, I lost my wallet, it had my medical and my pilot certificate, can I fly with a copy? Okay, again, my argument is you've got a fully scanned digital copy with everything you're supposed to have, and you're Part 91, not 135, not 121. I personally would feel comfortable flying to get home. I know the FAA's FSDO would disagree with me, but I don't think the FAA is going to bring an enforcement action.